All right, now let's move on to the second question that I said I would answer. Namely, what is distinctive about American property law? So to be sure, there are several distinctive features about American property law. But here, I will focus on what I see as the three most distinctive characteristics of American property law. So, of course, you will see exceptions to these generalizations, which I'm making, in various specific areas. But I do believe that as a whole, they represent the rule rather than the exception. So these three distinctive features are: one, that American property law is principally common law in origin; two, that American property law bears the imprint of legal realism; and three, that American property law is excessively pragmatic in structure and content. So let's go to the first of these, namely that American property law is principally or primarily common law in origin. So much like its English counterpart, American property law is almost entirely the creation of courts. That's what one means when they say it is common law in origin. The law developed through the formulations of rules created within the context of individual disputes between parties. And these rules had the chance to develop incrementally over extended periods of time, in the process adapting to various changing contexts, circumstances, and demands from society and around. Now, to be sure, when I'm saying that American property law is principally common law in origin, there are indeed areas where the legislature, either at the federal level or at the state level, has stepped in to either codify, crystallize, supplement, or modify court-made property law or court-made common law of property. But for the most part, it remains true that American property law is judge-made. So you may wonder, based on what I just said, namely that American property law, like its English common law counterpart, is common law in origin, what is so American about this common law method in property, if it exists in England as well? Well, the answer to that question lies in recognizing that the American version of common law is uniquely different, which in turn has important implications for property law. Let me explain. Unlike in England, here in America, we do not have a common law. Instead, we have multiple common laws, since the common law in the United States is for the most part state law. In other words, it's a creation of individual states, of which we have many. As a result, we have the common law of property developing in each individual state over time and through the individual decisions of state courts. So we have a plural set of common laws, so to speak. Now, this multiplicity of common laws for property certainly provides us, for the most part, I would say, with a common minimum denominator of law, which of course makes it easy to study for students. And the variations are fairly minor across the states when viewed on the whole, when taken as a whole. Yet, this multiplicity allows different common laws to experiment with different property rules and ideas before settling on one and choosing to remain with that one. And in the process, this provides other states with a menu, so to speak, to choose from of property rules whenever there exists a variation. And this, believe it or not, was a central idea behind the American system of federalism, where states are, to paraphrase Judge Brandeis, seen as the laboratories of experimentation in the law. And that's the reason we have different state common laws and different state common laws of property. Let's take an example, namely the law of adverse possession, which is a fairly well-known common law property doctrine. The law of adverse possession is concerned principally with ensuring the optimal use of land. And it works by seeking to reallocate land whenever it is encumbered or burdened by stale and old claims. So adverse possession, when this happens, requires a plaintiff, a person who is in possession of the land, what we would colloquially call a squatter, to show that his or her possession of the land was actual, exclusive, continuous, open and notorious, and additionally, and perhaps most importantly, adverse or hostile to the true owner for the entire period of what we call a statute of limitations. So in other words, when a squatter can show that his or her possession of the land meets these different elements for a particular period, either 10 or 20 or 30 years, that varies from state to state, the law says that that squatter can go to court and upon showing these elements become the owner of the land. The land then gets transferred from the previous owner who wasn't in possession to the squatter or the adverse possessor, so to speak. So adverse possession is, put very simply, a doctrine that redistributes land. Now, the big debate in adverse possession law has been what exactly the element of adverse or hostile means in terms of the plaintiff possessor's state of mind, right? So what does the plaintiff or possessor have to think? Does the plaintiff, possessor, have to occupy the land knowing that it wasn't his or hers? That is, we might say, in actual bad faith? Or should he or she have merely mistakenly believed that it was indeed his or her land, so in other words, in good faith? Or should the subjective state of mind matter at all? Should we just deem it irrelevant? Now, very importantly, you'll see, each permutation correlates with what the law of adverse possession chooses to emphasize as its principal stated purpose. Could it be incentivizing innocent but efficient use by the possessor? Or should we be deterring non-use by the original owner who slept on his or her rights? Or should we be deterring intentional squatting because that behavior is bad faith? And guess what? To be sure, different states developed different approaches. One set of states developed the rule that the plaintiff or the possessor, the adverse possessor, so to speak, needed to show an intent to possess the land of another for it to satisfy the adverse or hostile element. This rule came to be known as the Maine rule, since it originated in the state of Maine. Another set of states developed the idea around the same time, or a little after, that the intent idea was altogether meaningless, and that what the law should be focusing on, and the only thing that was relevant to determine this element, was the absence of permission. So as long as the adverse possessor, the plaintiff, didn't go and seek permission from the true owner, that's all that was necessary to satisfy the adverse element. Now, this rule was developed by the state of Connecticut and is today called the Connecticut rule. And some others developed the altogether different idea that a mistake was fine, but an intentional trespass was problematic. So if the possessor acted knowing that the property wasn't his or hers, that was problematic. So in other words, good faith behavior needed to be shown. Now, to date, there remains a plurality or multiplicity of views on the question, with, however, the Connecticut approach being the most dominant one today. Now, this plurality of views, or the multiplicity of positions and rules, can of course be seen as confusing at first blush. But on further reflection, you'll see that it allows different values and ideals to be debated during the conversation about the law, and perhaps more importantly, for an actual empirical examination of the effects of different rules before selecting one. This in turn allows change in the law, in American property law, to have a credible basis, as courts and occasionally legislators in one state borrow from the experience and learning of courts in another state. And through this process, American property law becomes richer and more dynamic in nature and content. So going back to our example of the law of adverse possession, the state of Maine has itself now come to abandon what we called the Maine rule. So in summary, this is the first distinctive characteristic of American property law, namely that it is principally and primarily common law in origin. And when I say common law in origin, it's not just a structural question that courts have for the most part created American property law, but that the very common law method has certain values and virtues because of the way in which it works in the United States. It has allowed for a plurality of American property laws with, of course, a minimum common denominator, but for extensive variation and experimentation on the margins whenever necessary.